Welcome to this video guide on dual employment during H-1B transfer. We'll explore the process of transitioning between H-1B employers and working for two employers during this period. This topic is complex and requires a nuanced understanding of the legalities involved. Here's what we're going to cover in this video. First, we'll discuss the legality of dual employment during H-1B transfer. Later, we'll delve into the potential issues and risks involved. We'll also provide you with recommendations and best practices to follow. Finally, we'll end with a crucial disclaimer. The H-1B portability rule plays a key role here, allowing you to begin working with a new employer after merely filing a transfer petition. But even before it is approved, it is important to know there is no outright prohibition against being paid by two employers for a brief period. However, this situation demands careful consideration of potential legal implications. Potential issues and risks are critical to understand in this process. Ensuring compliance is vital, as even short dual employment might attract scrutiny. Tax implications are also a concern, given the complexity of reporting income from two sources. Always be prepared to explain dual employment during applications for H-1B extension or green card processes. Ensuring the new employer understands their responsibilities in this scenario is imperative. There are several recommendations and best practices to follow. Primarily, always consult an attorney who specializes in H-1B visas for tailored advice. Comprehensive documentation is key. Keep every piece of communication and record neatly organized. Transparency is your best ally when approached by USCIS for explanations about dual employment. Now, it's quiz time. Here's your question. What does the H-1B portability rule allow? Your options are 1. Immediate start with new employer upon filing. 2. Working for multiple employers permanently. 3. Change employers without filing. Or 4. Receiving dual payments indefinitely. You may pause the video now to think about the answer. We will discuss the answer in the next section. The correct answer is immediate start with a new employer upon filing. The portability rule allows you to begin working with a new employer as soon as the transfer petition is filed, rather than waiting for its approval. Here we have a flowchart depicting the transition process during an H-1B transfer involving dual employment. This includes steps like consulting legal advice, conducting compliance checks, and managing documentation efficiently. To summarize, throughout this process, it's vital to understand the protections and limitations provided by the H-1B portability rule. Ensure compliance and stay informed about tax risks. Consulting with legal and tax professionals is not just recommended, but essential. Finally, a meticulous approach to documentation can safeguard you against future inquiries. It is essential to remember that this video is for informational purposes only. It does not substitute legal advice. Always seek guidance from qualified legal and tax professionals when dealing with your H-1B visa status and employment decisions. Thank you for watching our video guide on dual employment during H-1B transfer. If you found this information useful, do like, share, and subscribe. We would love to hear your thoughts on this topic in the comments. Until next time, take care.